following is a production of Temple University Beasley School of Law.
Thank you, Dean. The Dean sort of stole my thunder when I was going to introduce Morris, was to tell you the story of the Ku Klux Klan murder that took place many, many years ago. But every time we're on a program together, I always sort of force Morris into telling you that story. It's a very emotional thing. It's emotional for him. What I'm planning on doing today is just taking just a very few minutes to talk to you about a particular case that I handled, actually in Morris's hometown of Montgomery. And for all of you, I assume, are 3L, and that most of you are going to go into litigation. And the thing that I guess I really want to stress is something you're not going to learn in law school, and you'll hopefully learn it as you practice law. It took me over 50 years to appreciate what the story I'm getting ready to tell you. What happened was in July of 2007, there's a device, an off-road vehicle called a Rhino. It's produced by Yamaha, and it's actually what's called a utility terrain vehicle, which is distinguished from an ATV. But anyhow, what it is, it's a four-wheel, small off-road vehicle with a steering wheel, and the accelerator and the brakes are on the floor. My client in July of 2007 was driving this vehicle on flat terrain at a reasonably slow speed, made a sharp turn to the right when it flipped over, and she had a bad leg injury. And that was in July of 2007. October 2010, in Montgomery, Alabama. And I was able to point out that, I guess, during the 3 or 4 years that they were developing the Rhino, that all the mistakes they made, the center of gravity was too low, the distance between the ground clearance and the vehicle was too high, that the track width was too narrow, and as a result of this, that it had a tendency to tip over. The trial lasted 3 weeks, and during that time, I presented all of this, what I thought was fabulous evidence of all of the defects in the Rhino. They came on with their case, and they showed all of the great things they did in developing the Rhino, that they were the first to put seat belts on. Even after our accident, they were the first UTV to put doors on these vehicles. And they went on and on and on. Anyhow, a 3-week trial, the judge orders pizza for the jury because it happened to be at lunchtime, and it took the jury 30 minutes to eat their lunch and then eat my lunch by coming back with a defense verdict. And so that was the extent of it. And we went back to the hotel, and we were leaving to go to dinner that evening, the 3 or 4 of us, and I look over there in the bar, and they're celebrating and drinking and partying, and how can it take that? But then the next day, the press release came out, and it was horrible. So I said, heck, we already had a transcript done, the daily transcript. So I said we'd go ahead and appeal. Well, we go ahead and we appeal it, and it's turned around, and the Alabama Supreme Court, which was surprising, sent it back for a new trial. All right, and this was in April of 2013. We go back to trial, but it so upset the trial judge that she said, because she was upset that it had been reversed, and so she turned around and said, there will be no new evidence, every witness will be the same, everything is going to be exactly the same, and we'll see what happens. Well, so we go to trial. All right, this time, after a 3-week trial, the jury goes out, and it returns their verdict of $3.4 million. They were out about a couple of hours, and interestingly, they gave $1,400,000 for the leg injury. I'd asked them for $1,000 for the punitives, and the jury came back with $2 million in punitive damages. All right. What happened? What was the difference? Here's the exact same evidence, the exact same witnesses, the exact same judge, nothing new except theme. And that's what I want to talk to you about. The difference was that in the first trial, the one that took them 30 minutes to eat their pizza and come back with a defense verdict, I was attacking the vehicle itself, the Rhino. It had too low of center of gravity, too high ground clearance, too narrow the width of the vehicle, and all, just all of those things. In the second trial, what I did, I basically stole their thunder. I said, when we started off, right in the opening statement, I said, they did a great job in developing the Rhino. They did all of these things. They spent 4,000 hours doing testing, and they did this, and they did that. They did all of these things. And then within a couple of years, after the vehicle was on the market and had become the fastest-selling off-road vehicle in the world, that these things were tipping over, and they continued to sell. They did not stop. They did not stop manufacturing. They did not stop selling the vehicle. So what we had done from a theme standpoint is, instead of attacking the vehicle itself, we went ahead and attacked the company. And that's what the difference between a defense verdict in that particular case and a plaintiff's verdict. And I guess that it's something that you will, over the years, as you're trying cases, you begin to, whether it's in front of a judge, in front of an appellate court, in front of a jury, theme becomes so important. And like I said, it took 50 years for me to have the exact same situation to prove the point that theme, this is something to say, they can't teach it to you in law school. You start to think about it as to how to present your overall case. And anyhow, what we're going to do, I just wanted to point out the question theme, and then Morris is going to come up here right now and is going to tell you about a number of things, and I would hope he would tell you the story of the Ku Klux Klan situation that took place in Mobile, Alabama. One interesting thing, and then I'm going to sit down, about the second trial and the case, the Rhino case. It was both cases, predominantly African-American jury. And that in the second trial, before I was ready to make my opening statement, the defense called me up and in front of the judge, and they said, Your Honor, in the back of that courtroom is Morris Dees, and he has to be removed from the courtroom. And I said, why? He said, well, the way he is, and people in Montgomery, they, especially in the African-American community, love Morris, and he's over there, sitting over there near the plaintiff. We got into one hell of an argument. Morris is sitting there, and he comes up, and he says, hell, it's a public courtroom. I can stay here. One thing led to another, and I said, Morris, listen, I knew things were going our way. Anyhow, I said, we're kicking their butt. Go ahead and get out. So anyhow, he got out, but we still got that. But I thought it was interesting that these are little things that can happen in a courtroom that you were not trained in law school as to what to do. It's the first time I've had that. But anyhow, you're in for a real treat with Morris and telling you about some stories. I hope he does the one about the murder that took place in Mobile. Anyhow, thank you. And we'll be back to do question and answers afterwards. Okay. I'll get you.
Thank you, Fred. He did talk about the change of the theme in that case, and my law partner, Richie Cohen, and he had some conversations about it, and Richie made a suggestion, and Fred followed up. he started his opening statement by saying, in the second trial, that you're going to get a chance to see how corporate America works. A chance that most people, citizens, never see. You're going to go in the boardroom. You're going to go in the engineering places where they make the decisions to make products that affect our lives. Pretty much it. Well, I'm a trial lawyer, and I guess I grew up on a country farm, arguing stuff with my neighbors and others. And the first case I tried was representing, at 16 years old, me, before a justice of the peace, an African-American man who drove a tractor for $4 a day in 1940, 51 or so. He was arrested by a deputy sheriff for being drunk and for assaulting a police officer, and he wasn't guilty of any of the above. And I went there to speak out for him, and it didn't make any difference because the judge took the word of the deputy sheriff, and they fined this man more money than he was going to make in 3 months. And I went back to my daddy's putting the planters, the cotton planters, on the tractor, and we were tenant farmers. We didn't own any land. We just rented, and this black guy worked with us. And I was mad, and I was throwing rocks up against the tin barn, hacked off that I had lost my first case. And Daddy said, well, if you want to do something about it, son, go to law school. Well, I did go to law school with the idea that I would try to help those people who, well, a better way to put it, have few champions. And how many of you in here, when you came to law school, and maybe still today, just raise your hand if you thought one day you might stand up in some forum, some courtroom, somewhere, speaking out for somebody whose rights have been violated. How many would you say? Okay. Well, it won't be long for many of you, but one day you'll prepare your case as well as you possibly can. You'll have all of your exhibits. You'll have taken all your depositions. You'll practiced your opening statement. You've got your best suit of clothes on. You go in to present your case. The opposing counsel will be sitting there equally prepared with you. And you'll open your presentation by saying, and may it please the arbitrator. And the reason I say that is because jury trials are becoming fewer and fewer and far between. There'll be a day when you will be able to come through this hall out here and punch the buttons and listen to some, take me out of that, great trial lawyers of America tell their stories. In this Trial Lawyers Hall of Fame that Temple University has agreed to allow to be put here, and it'll grow as time goes on. And that'll be where you'll learn about trials, unless you decide to do something about it. Because it's going to be up to you not to allow corporate America, the Federalist Society, and other people who know how to kick justice to the curb to end jury trials in America. It's really a significant part of our history. Everybody knows what the Sixth Amendment is. Dean, you know what it is? What is it? What is it? She gets an A for that. Who can tell me, student, what the Seventh Amendment is? The U.S. Constitution. Now, you don't get to do it again. Come on, somebody, please, quick. Well, you know, what it says is you have the right to a jury trial in all civil proceedings in America that amount to $25 or more. To put an inflation kicker on that, it'd probably be a few thousand today. But all across America, jury trials are being eliminated. One fashion or another, corporate America, who doesn't trust the people, have come up with ways to do that. First, to put judges in there who kick your case away because of some summary judgment motion because the judge decides no reasonable jury could possibly rule for the poor plaintiff in the case, and so therefore this case is dismissed, and so many other fashions in so many other ways. You know, the history of our judicial system is steeped in the right to jury trials. And it's going to take people like you to keep that tradition going. And not when they offer your client some pittance because they've convinced you that the mediator is not going to give you any more and you're not going to get a fair jury trial, and the jury is already poisoned against you anyway because they've listened to all the stuff that's being promoted as propaganda, how jury trials raise the price of things in America when in fact it's totally untrue. Jury trials in this country and the work of plaintiffs' lawyers has probably saved more lives than the President of the State Commission ever saved because they pointed out the horrible products that need fixing. But when you get laid on your table an opportunity to take the money that they're offering you, don't do it. Don't do it. I've seen Fred take cases, and a book just been published about him, and I hope you find it and get it and read it because it's a great, great piece of work. And one of the first cases he did was where somebody came in that instead of giving the drugstore and instead of taking a 50 milligram pill, gave this person a 500 milligram pill, and it caused an enormous amount of damage, and he got a verdict of several $100,000, which is a landmark at the time, when other lawyers backed away, and he refused to take the few coins that the drug company's insurance offered him. But this country was steeped in the right to jury trial even before we had a constitution. Back in 1773, I believe, a young lawyer in Boston named John Adams had become a pretty good lawyer and had made a name for himself, trying cases. And he was asked to try a case that he won, and people wondered this day how this clever young lawyer did this, but a boat was captured coming into Boston Harbor with some Madeira wine, trying to slip past the British taxing authorities, didn't want to pay the tax. Well, they put the captain in jail. They seized his boat, and I don't know how John Adams did it, but maybe the judge now was trying the case, had his finger in the wind, and thought this, and they wanted to, worried about this little budding revolution that was going on. And Adams' cousin Samuel Adams was kind of leading this pack, and so Adams got this man cleared, got his boat back, got his cargo back. Well, the name of that boat was Miss Liberty, and the captain of that boat was none other than John Hancock. Well, Adams continued to work in the favor of throwing off the horrible bridle of the King George was going around in the colonies, and a group of citizens in Boston Commons, had a big demonstration, and they, began to throw rocks and bottles at the redcoat policemen of the day, and they were 7 or 8 of them walking around there, and they got pretty rowdy there, and so throwing rocks and bottles and hit a couple of the redcoats with the bricks, and so the redcoats fired into the crowd. People were rushing them. You know this as the Boston Massacre. Well, the governor appointed by King George figured he'd find, some lawyer there to take the case. They were doing a lot of business with the Crown because the governor wanted those officers prosecuted because he had his finger in the wind too, and he wanted to appease the citizens. But he figured that, he'd get an acquittal, or some great lawyer would step forward, and, they had the billable hour crowd of that day too, and they were representing the king's companies, and so they couldn't find anybody to take the case, though. But all these lawyers and those big law firms in Boston found a convenient conflict of interest, so they didn't take the case. And Adams was called in by the governor and the prosecutor and said, sir, you're well known as a good trial lawyer, and would you represent Captain Preston and these soldiers? And Adams thought about it, and I said, I'll let you know. And he went back and talked to his friends, and they said, well, man, you'd be a fool to take this unpopular case. You're gonna have a role in this country, this leadership in this country one day. Well, Adams took the case anyway, and he put on the best defense that he could. And I was reading, I think I got this thing here. I was reading a book recently talking about Adams in this case. And a historian wrote that Adams' brilliant summation revealed his awareness of the potential personal and political risk of him taking this unpopular case. But Adams declared that if he could save only one life, the blessings and tears of that one person would be for him a sufficient consolation for the contempt of the masses. And John Adams, in his own autobiography, wrote that his defense of Captain Preston and the 8 British soldiers that he acquitted of murder was one of the best pieces of service he ever rendered his country, because he made sure that the law and the right to trial by jury and not the mob would rule. You know, there are tyrants today, like there was tyrant in King George's time. I was speaking to a group of law students one time, and a young woman student was sitting there, and a young lady in the front, and she had one of these T-shirts on, and I said, well, you know, why you got that T-shirt on? There's a Q&A, and she said, well, people are making fun of me going to law school, and, you know, my family said lawyers are just, you know, why do you want to be a lawyer? They just do the worst kind of things and all that. I said, well, I'll tell you what you do, and the rest of you here, because you can't see your T-shirt, so I'm just going to tell you what you ought to do. And actually, Howard Nation, sitting in the back with the white hair in the center, one of America's greatest trial lawyers, told me this story, why I was able to use it. I said, madam, I want you to do this. Before you leave law school, I want you to go to the library and go to Shakespeare and pick out Henry VI. And what you'll learn is that T-shirt that you're wearing doesn't have the full slogan on it. Because what Henry VI said in there through Shakespeare, if tyranny is to prevail, you must first kill all the lawyers. And that was on a T-shirt. And there are tyrants today, too, and the ones that you are going to face. And I'll mention a few, and you know them, too. There are automobile companies today who know long in advance that the switch on the Chevrolet cars was defective. They made a little calculation they would hide that, and it would probably cost them more to pay off the few deaths if people could figure it out. And they lied about the deaths, and they hired the biggest law firm in Atlanta, Georgia, King and Spalding, to make sure that they deep-sixed all the material, and it finally came to light. I mean, you go out on the street, and probably every other car goes by is General Motors. That's a tyrant right there. And think about all these people that sell stock, Merrill Lynch and all the rest of them. It isn't a week go by that they don't pay $500, $600, $800 million for defrauding people, and yet they're still on television. And please let us handle your money for your aging mama, you know. And then you've got banks. Citicorp, one of them is recently going to pay like $17 billion for cheating people in the housing scandal. Another tyrant. You got tyrants on a lower level. You got a system, a criminal justice system that executes people that are probably not guilty. They don't get much of a lawyer. But there have been dozens who've been released who spent 20 or 30 years on death row who were totally innocent. And there's one case in the New York Times yesterday, a day before. Read it. Go get it. It's where this super bubba prosecutor down in North Carolina, he had like 70 death penalty verdicts. He's trying to put these two kind of black guys who wasn't too smart, low IQ, put them on death row for raping and killing a young white woman. And a week after that, another white woman was raped and killed. They caught the guy who did it, and it turned out that he also did this too with some DNA checking, but they spent 30 years on death row. So that's another tyrant. That tyrant is America's criminal justice system that still uses capital punishment in a time when there's not a civilized country on this earth that has a death penalty. None, not one. Even Mexico, we think of third world country, has no national death penalty. And only one state in Mexico has a death penalty by its own rules, but hadn't been anybody executed since that revolution many years ago. And then you've got title loan and payday loan people. I don't know if you have them up this area, but they got plenty of them down south. And they just sucking the blood out of people. And those are tyrants. And then there are small tyrants you run into, like a used car dealer who knows the transmission on the car is no good, so they put some extra thick lubrication in it, and then here comes a single mom along, and Harley has enough money to buy milk for the baby and working at McDonald's, and she gets the car to get to work, and she drives the thing out of the store, shop, the used car lot, and it doesn't last but a week or two. They knew it wasn't going to last. She comes back, oh, no, you're not going to take this back. And it takes a great lawyer to represent her because you're not going to get a big fee, get a fee at all. And when I talk about these cases, and it's what Fred points out, is that the compensation you get for using your legal training to help those with few champions is the relationship you make with the people you represent. I think about the cases that I've done, and I know you'll have many of them, and you'll come home and tell your significant other, and then later your children, and later your grandchildren about this, because it won't be the size of your bank balance you'll talk about. It'll be the people that you help if you are truly going to be a trial lawyer. I think about the black Marine sergeant in Cordele, Georgia, that I later learned to call Rawdale, Georgia, because he shot and killed 2 police officers, and it took us 15 years to free him. And I think about him on the day he walked out, and I think about the young Latino woman, Ms. Ruiz, who had a baby in Singing River Hospital in Gulfport, Mississippi. Couldn't speak English. She was undocumented, worked in a restaurant 6 days a week, 14 hours a day, goes to the emergency room to have this baby, and within the next day, the baby was taken from her, given to a white couple who everybody knew was looking for a baby in that little small town because they said she didn't speak well enough English to take care of this child. It took us 11 months to reunite her with her child, and now she lives in Oaxaca, Mexico, and we're suing the hospital and the Department of Human Resources of Mississippi. I can go on and on talking to you about the people whose lives that we've affected with our work. Even long before I founded the law center, I've been practicing law 54 years. And I remember out of law school taking cases that kind of guided me along the way that I ended up when we founded the Southern Poverty Law Center in Montgomery. Now we have 43 lawyers and offices in many cities across the South. And a graduate of this school is, I can announce this, I think, because we put it on our internet. So, is a graduate of Temple is going to become our next legal director, Rhonda Brownstein. And she's quite a lawyer, works here in Philadelphia now with the Juvenile Justice Project. And she came to work for us for 1 year as an intern, got an intern fellowship, and then came back for 8 or 10 years to be a legal director and a lawyer. And I tried a number of cases with Rhonda, one down in Pensacola, Fred's hometown, representing the doctor, the first doctor in America killed, in an abortion doctor killed by the fanatics. And we ended up getting a $1 million judgment against that group and took away some of their property and all. And Rhonda is a passionate lawyer, and she is there every day in the trenches working. She helped us in a case in South Carolina representing a black church. It was burned by the Carolina Knights of the Ku Klux Klan. And we asked the jury in that case, and Rhonda helped us argue the case, to give us $26 million because that Bible was pretty valuable. The church wasn't valuable. If that Bible that was burned, we made it to be the Bible that Jesus probably gave God. You know, well, somebody gave it to him, but the jury came back with $36 million. Klan lawyer was baffled, and I was too. So I asked the jury, and Rhonda standing right there with me, I said, why did you come back with a jury verdict of $26 million when we only asked 36, we asked for 26? And the foreman of the jury said, Lawyer Dees, that's what y'all wanted. We want to do something on our own. And as Fred urged me to tell this story, and it's a story about I guess you'd say an iconic case that the Southern Poverty Law Center handled, and it was tried in 1987, and it wasn't the first hate group case we'd done. We represented the Vietnamese fishermen when the Klan was burning their boats, and we had represented some other people, but this is the first one that we had was the jury trial. And it's a case that is going to be the subject of a book that a well-known writer is doing, and I'm not sure what he's going to call it, maybe The Last Lynching. I'm not sure. Titles go through different iterations. It ought to be out within the next 6 months. Simon & Schuster's publishing, and the editor there is the editor who is responsible for the book Butler being published. So it could be a good book. I've tried to change some stuff in it, but I'm not writing it. I don't like the way he puts some stuff. He started talking about me personally, but he won't let me do it. So you're gonna see it. You're gonna see it, warts and all. But it was 1981, and a trial was going on in Mobile, Alabama. A black guy in Birmingham had killed a cop in a bank robbery escape. Got so much publicity, they moved the trial to Mobile. Change of venue. And the trial was being watched very carefully by members of the United Klans of America. That's the group whose members bombed the church in Birmingham that killed those 4 little girls, and killed Viola Liuzzo on the march from Selma to Montgomery, and did so many horrible things. And in the late 80s, we had double-digit unemployment and interest rates and other things when Carter was president. We'd lost the Vietnam War, and these Klan, got a rebirth because America's obviously going to hell in a handbasket here, and it was the reason is because the Jews, naturally, they control everything, and they control the blacks, and the blacks taking over, and the Klan, they saw this enemy out there, and the Jews were just using blacks as a tool, and they saw that trial going on in Mobile, Alabama, and the jury that was picked was 11 blacks and 1 white. And official of this Klan group, who had chapters in 30 states at the time, was the most powerful Klan group around, contacted the national office and said, we need to do something here, because if that jury doesn't convict this black man for killing this white police officer, then that's not going to be right. So they all met, and they decided that if that jury didn't convict, that they were going to find a black person. I promise you, from the evidence, we got a couple of Klansmen to flip and talk to us. They didn't use black. They used the big N word in a Klan meeting out in the woods on the edge of Mobile. And so the trial went on, and it was a deadlocked jury. The Klan thought that was a defeat. And they had picked 2 young Klansmen, James Tiger Knowles and Henry Hayes, and they'd given them a noose and a gun and a car to use, that if that jury verdict came in that they didn't like, they were going to abduct the black person and take him out and hang him in a way that the people would know that if blacks served on juries, they better be careful, because they're affecting the interests of white people, and they couldn't do that. And they're going to put fear of God in them. Do what the Klan has always done, lynch people and do things outside of the law. So after that verdict came in, they saw it on the 10 o'clock news. 2 young white men went out, and they drove up and down the streets of Mobile, Alabama, until they found this one young black man who was walking down the street, minding his own business. He looked easy to kidnap, so they drove up beside Michael Donald. That's Mr. Donald's only son. A fine young man. He was a leader in his church. He was going to bricklaying school. He was working at night at the Mobile Fresh Register, had a good job, and he had 5 or 6 sisters, and they were poor people. His mother lived in a housing project there. and asked him the direction to a restaurant. And he walked up to the car, and when he did, they put a pistol in his face and forced him into the car. He didn't know who they were, and they wasn't dressed with Klan stuff on, and he got in the back seat with one of them was in the back seat, and they drove around, and he said, "Look, don't y'all hurt me." He said, "My mama depends on me. Don't hurt me." He said, "Yeah, I don't have anything, but just you can have what I got." But they took him on across the Bayou Bridge over into another county and got him out of the car, and he took off running. He was afraid, and they raced him, tracked him down, and tackled him and hit him in the head with a club or two, and had the gun. It fired by mistake into the air, and they ended up losing it there. And then they took the noose out and put it around his neck and pulled on it with all their might. One got on one side and put his boot up against his face, and the other on the other, and they pulled on that rope until the waffle boot prints of his face was later seen in the autopsy photograph. The FBI got involved, and they finally caught these Klansmen because the youngest one had gotten involved in some other crimes, and the FBI had gotten involved 3 years after the murder, and they finally convicted. They finally got the young Klansman to plead guilty. They gave him a life sentence in a federal witness protection program. And he agreed to testify against the older Klansman, 9 years older, for this life sentence, violating the federal civil rights law. Well, I went to that trial, that criminal trial, and I sat there, and as the lawyer for the Donald family, our goal was not just to go after these two Klansmen, but to go after the organization who nobody had ever sued an organization for the acts of its criminal acts of its members, just not in the law books. But I knew what the United Klans had done, and as soon as we found out these two young fellows were part of it, the plan was in action. And I watched that trial. Miss Donald didn't come because it was so painful for her to be there. Her family was there, and I watched that jury, a jury of 11 whites and 1 black this time, convict this older Klansman. He got the death penalty, and as much as I opposed the death penalty, he was executed later, and he was the first African American known in our history first white, known in our history for being executed for killing a black person in Alabama. He got one way back in the 1800s or something. And after the trial, through the FBI and Justice Department, I approached this young Klansman who had testified. I said, talk to me. Tell me how this thing took place. What happened? How'd y'all get to do this? So over a 3 or 4 year period, we developed quite a bit of evidence showing that it was a plan that was approved at the highest levels. And so we sued the United Klans of America, as well as some of these individuals. And we sued, the Klan had a good lawyer there. They had money and property. And we sued this young Klansman who had done this and several others who had no lawyers. We wasn't looking for money. We wanted the jury, they wanted to be there so the jury could see the whole cast of characters. Miss Donald came to the trial, and she sat at our counsel table in front of that all-white jury in federal court. And I know that as James Knowles testified, James Tiger Knowles, who now was in his mid-20s, and I showed him that photograph, that autopsy photograph of that boot print. I know that Ms. Donald couldn't have helped but have seen that photograph and those boot prints as I passed that photograph over to the jury. Put on a lot of evidence, and at the end of the trial, the judge gave us a chance to do closing arguments. Klan lawyer made his, and he did a good job. In fact, he's a pretty well-known and successful Alabama lawyer now. He does a lot of capital punishment work. Everybody deserves a good lawyer and a good defense, regardless of the popularity of the case. John Adams proved that, and by John Adams taking that case, it didn't hurt him because he became the second president of the United States. Well, the Klan lawyer said, look, we have free speech rights, our organization for that, and we can't help what these renegades went and did. And I said, my closing argument, I said, now we've shown you incident after incident, from the Freedom Riders beatings and the killing of Vallaluzzo. I went through the whole thing. The National Klan and its officials were involved in it. They orchestrated, and I had got several Klansmen who were older, and one was in a federal prison for doing it, to get up there and testify that he had met with the leader of the Klan before an incident, and he told him what to do. And I asked the jury, I said, render a verdict so that one day, when they're calling out the names of those people who gave their lives in the struggle for human dignity, when they call out the name of Martin Luther King, Medgar Evers, Valerie Lizzo, so many more, render a verdict so that one day they'll call out the name of Michael Donald. I sat down. The judge was beginning to charge the jury and tell the jury what the law was that they were to apply the facts with, when James Knowles, this Klansman who was brought there by the FBI, and they sat all around him out there in the courtroom, jumped to his feet, and he, I guess we thought he was fixing to try to escape. But he said, Your Honor, he said, I don't have a lawyer, and I didn't even understand that arguments were made like this, and I'd like to say something to the jury. Judge called us all to the bench, and naturally did not want a reversible error, so we said, sure. And the Klan lawyer didn't even care. He just missed the point of the whole case. He missed the point by thinking that his First Amendment was going to get him off. He didn't care what these crazy fools said. So this young man stood there, and Ms. Donald was sitting about as far as Dean him as he stood in front of the jury, and he said, ladies and gentlemen, everything that Mr. Dees said is true. These Klan leaders over there at the other side, they're the ones that put us up to this. They told us what to do. And then he said, I lost everything. I'm never going to ever get to see my children. He had one child at that point in his 20s. That my life is ruined because of what these people did. And he looked at Miss Donald sitting there, and I guess he must have felt her life was ruined too. And he looked at her for a moment, and he choked up and started crying. Tears were streaming down his face. And I thought the judge was going to declare recess to give him a chance to regain his composure, when he cleared his throat and he looked at Miss Donald sitting there and said, Miss Donald, can you find it in your heart to forgive me for what I did to Michael? And she kind of rocked back in her chair. And I promise you, if I try another 100 cases, 1,000 cases, I'll never be so moved. She looked at him in front of that jury and said, Son, I've already forgiven you. I thought to myself that she had the understanding, the love, and the mercy to forgive this man who had taken her only son, because she understood the pain of suffering, discrimination. And I thought the words that came out of her mouth that evening was a higher justice than that $7 million verdict that jury later rendered. And it's people like Mrs. Donald and the other people that I've represented, that Howard's represented, that Fred's represented, and the people on this wall that you walk through their pictures, take time to listen to what they have to say on that little kiosk. It's made our lives richer. It was Mrs. Donald who caused me to wonder who has been killed in the civil rights movement. We did some research. Eyes on the Prize, the definitive work, listed only 20 people. After research, we found 40. And because of her inspiration, we built the Civil Rights Memorial Center in Montgomery. Ma Lin, who did the Vietnam War Memorial, came down and designed it. It's a beautiful piece of work. You can see it online. And tells the stories of the 40 men, women, and children who died in the civil rights movement. I like to end by saying that you might think, well, how can I do cases like Fred did? How can I bring down the tobacco companies? He orchestrated a $13 billion verdict in Florida against the tobacco companies, probably saved hundreds of thousands of lives and started that ball rolling. I can't do that because I'm not Fred Levin, or I'm not any one of these other great lawyers. But Fred didn't start out suing tobacco companies. He started out taking some little penny ante case in Pensacola, Florida. And I started out representing people in the police court. That's how you learn to practice law. But it's going to be up to you to I guess, think about the legacy that's been handed to you when you get a law degree. There's nothing wrong with making money practicing law. Corporations need good lawyers, and they ought to have good lawyers because maybe some good lawyers with a conscience will tell them that they don't want that memo in the file you wrote about that drug killing people to be seen, so maybe they ought to do right. Corporations need good lawyers. You need good prosecutors. You need good judges. But you also need lawyers who understand that America is run by the rule of law and not by judges and not by the Federalist Society who wants to pack our courts with corporate-minded lawyers who put them on our Supreme Court, and presidents who put, after Justice Marshall, one of the greatest jurists, lawyers who ever existed in this country, replace him with somebody like Clarence Thomas from Pinpoint, Georgia. I don't think he's asked a question. He's been on there in years, and it's just an abomination on our courts, all I can say. But it's up to you to make sure that doesn't happen in this nation, because you hold the keys to the gates of justice. Remember that. You hold the keys to the gates of justice. And there are words that go across that 70-foot black granite wall at the Southern Poverty Law Center, words that Dr. Martin Luther King spoke in that famous speech in Washington, D.C., but words he didn't make up. He chose those words from the book of Amos when the Jewish people, the children of Israel, were not following the law of justice. And Amos admonished them, and he said, let's don't be satisfied until justice rolls down like waters and righteousness like a mighty stream. Thank y'all.